Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Today is, of course, this is Legal Friday, so coming aboard with me, Alex Ooley from the Ooley Law Offices in Indiana, also the Forge of Freedom podcast. Alex, thanks for coming along today, man.
Yeah, great to be with you, Paul.
Let's see. I'm going to move this over here so I can see who's commenting, and let's go ahead and get started. First topic. Well, first of all, I keep forgetting this, but I need to do it every time you're on with me. Even though you're an attorney, nothing we are about to say is legal advice. You are licensed in Indiana. You practice out of Southern Indiana. If somebody needs legal advice, they need to get an attorney in their jurisdiction. And of course, you cannot give legal advice over the air. So if you're watching us today on either the Polite Society Facebook or YouTube page, you can comment on those and we'll get those right away. We'll get them up on the air if they're about what we're talking about. If you're catching us anywhere else, normally I send you to Twitter to tweet with the hashtag #TheBullet. However, Twitter is not allowing access to my broadcast software anymore. So if you really want to get a comment in, go to Facebook, go to YouTube, comment on one of those. But we are everywhere. We're on Getter, we're on Rumble, we're on OpsLens, we're on all kinds of distribution systems, and you can get us pretty much anywhere. Anyway, let's get started, Alex. First story up. This one is one actually you suggested out of Indiana. This is from NRA-ILA. Yesterday, Governor Eric Holcomb signed House Bill 1323 into law. It prohibits the release of any carry permit holder and applicant data to federal entities except for single entry queries only for individuals who are subjects of criminal investigation or following an arrest. I think that's good. This basically what the law is it doesn't allow the federal government to come in and say who's got permits in Indiana and add those people to some federal registry.
Yeah, that's exactly right. Got a little bit of good news here from my home state of Indiana. Governor Eric Holcomb hasn't always been the most staunch gun advocate here in Indiana. In fact, he was quiet during the legislative session last year when the legislature was debating constitutional carry or permitless carry here in Indiana. I think because he secretly or sort of not so secretly eventually did not support constitutional carry, but I'm glad to see that he did sign some favorable legislation into law here in Indiana this year. And of course he did sign permitless carry into law last year, but only because his hand was sort of forced in that regard. But yeah, this is good news. This ensures that information, held by Indiana can't be used to build a federal registry, like you said. So it's a little bit of good news here in Indiana.
And Indiana is not one of the states. California is. In Illinois, may be becoming, especially with AR-15s. Illinois' law says you've got to register them this year. New York and some other states have registries in the state, but Indiana does not, right?
Right. Indiana does not have any sort of registration.
Very cool. Next one, I knew about this story a few days ago, but I wanted to hold it for today simply because you'd be here. This one really was a shocker to me. This comes off AmmoLand. Attorney General Merrick Garland plans to petition the Supreme Court for a writ of certiorari to settle the circuit court split surrounding bump stocks. The case, Cargill versus Garland, in which Michael Cargill sued the Department of Justice for directing BATFE to change its rule on bump stocks. ATF would redesignate bump stocks to be machine guns, even though the device did not meet the criteria laid out in the National Firearms Act of 1934. I'm going to go ahead and stop reading the story there simply because I'm not reading so well. But what surprised me about this is anybody who has even passing knowledge of recent events and passing knowledge of the Bruin decision should know that if this gets to the Supreme Court, Thomas and the group up there are going to knock down that ATF ruling. The fact that Garland is asking them to take it, either the guy is smoking something that is against federal regulations, or he really believes they're going to side with him.
Yeah, I don't think he probably believes that the Supreme Court's going to side with him, but there's this thing called a circuit split, and there's disagreement among the circuits at this point. So there's not really clear guidance or uniform application of the law because the various federal circuit courts are in disagreement. So I'm sure that Merrick Garland here is just seeking clarification so that they know how to proceed. That they would have a hard time proceeding with the law or deciding not to proceed with the law if all the federal circuit courts are in disagreement. The article here points out that 4 cases attacking the bump stock rule were filed. The government won, meaning the bump stock classification as a machine gun was upheld in the Circuit Court for D.C. and the 10th Circuit Court of Appeals. And then there was an 8-8. This is interesting too. There was an 8-8 tie in the 6th Circuit, and because of the tie, the district judge, that is the trial court judge's ruling, stood in favor of the government. So you had 3 circuits in favor of the government, upholding the bump stock classification by the ATF, and then the 5th Circuit deciding against the ATF and the Department of Justice. So you've got disagreement now among the circuits. And if you don't mind, Paul, to go ahead and put up that map that we have of the circuit courts. For folks who don't know, there's at the federal court level, there are federal trial courts, which are called district courts, and then there are federal circuit courts, which are the intermediate courts of appeal in the federal court system. And you can see on the map, if you're watching by video, the 10th Circuit, which includes Colorado, New Mexico, Wyoming, and a few other states. And then the 6th Circuit, which includes Michigan, Ohio, Kentucky, and Tennessee, sided with the government, but the 5th Circuit down there with Texas decided against the government. So because you have disagreement among those, the Supreme Court is more likely to grant review, grant certiorari, because that's one way that the Supreme Court prioritizes which cases they are going to actually review and decide. The Supreme Court reviews a very small percentage of the cases that they are asked to review. I think it's less than 2%. I don't have the exact figure at my fingertips. But one of the ways they prioritize which cases they review is whether there's disagreement among the circuits. And here there is. So the court, I think, will likely grant review of this.
I would agree with that. And if I were Merrick Garland, thank goodness I'm not, but I would want to keep this out of SCOTUS until at some point maybe they get a more favorable lineup. Right now, as the court is set right now, I don't see a prayer of a chance that the bump stock ban stands. But
yeah,
admittedly, I'm biased, but I don't see how it could stand with the current court. So.
Yeah, and I can only speculate about what the strategy is here by the Department of Justice, but they may know they're going to lose or suspect that they're going to lose, but they can just sort of wash their hands of it and say, hey, we did what we could. We tried to restrict this that we consider to be dangerous, but the Supreme Court decided against us, so it's their fault that we couldn't get this common sense gun control type legislation through or rulemaking.
You get a comment in here, and I think Robert is right there with us. He commented on the YouTube side. It's a political stunt to be able to use it as propaganda in the next election. Yeah, it's when they lose, they can certainly spin it that way.
Yeah, I think that's a good thought. I think that's probably what's going on, but again, just sort of speculating.
He also says they will claim that SCOTUS is allowing people to have machine guns. You know, I want to. I don't own a bump stock. I never have owned a bump stock. I have fired bump stocks before. I've fired ARs with bump stocks on them, and they're a great toy. I don't see a single effective use for them other than possibly cover fire. However, I honestly believe this is such a huge overstep by the ATF. I believe it's your right to have one. I believe you should be able to own one. And for me personally, I don't see a practical use for them. But
Yeah, I agree with you, Paul. I don't see any practical use. But at the same time, I don't think they should be regulated by the federal government.
oh, I absolutely agree with that one wholeheartedly. And then I want to also mention before I forget and we get off the story, if you are watching now and you are concerned about bump stocks, do tune in Monday evening to the Polite Society podcast because Michael Cargill of this lawsuit is going to be our guest Monday evening. So you'll want to tune into that.
And of course, I hope that the lawsuits challenging the pistol brace ban or pistol brace rule are successful. But I think these cases involving the bump stock ban are even stronger because here the ATF basically redefines what a machine gun is under the statute. It essentially rewrites the statute, which violates the separation of powers because that's something that the legislature has to do. Whereas with the pistol brace ban, or not ban, but the pistol brace rule, there's a little more ambiguity there because the ATF isn't rewriting the statute, they're reinterpreting the statute, which is within their province to do. I think it's just inappropriate. I think it's beyond their authority under the Administrative Procedures Act. I think it's in violation of the Bruin decision, these sorts of regulations and taxes. So I hope it can be challenged and those suits can prevail. But I think will likely be on other grounds.
Yeah. One more comment and we'll move on here. Again, Robert. Well, the AFT at one point claimed that rubber bands were machine guns. Yeah, at one point they were saying anything that allows the firearm to fire rapidly could be termed a machine gun. They had to back off of that one. I think they'll have to back off this one too. Anybody with a little bit of ingenuity and belt loops knows how to bump fire an AR. There's only so much they can outlaw, man.
Yeah, exactly. And of course, it's all for naught because none of these things will prevent the sorts of tragedies they proclaim to be attempting to prevent. The bump stock ban was in the wake of the mass murder in Las Vegas, and for those who don't remember, it was during Trump's presidency. So these sorts of rules that we're now fighting were a result of lawmaking during Trump's presidency. So it's just another example of how we can't let our guard down even when we have a Republican president.
I lied. I need to get one more comment in that just popped. Charlie Cook says Jerry Mikulic's index finger is a machine gun. Yeah, Mikulic's finger, I swear to you, man, is faster than a bump stock. Alex, I just off the top of my head, I remember that Jerry was firing. What was it? It was a Barrett. He was firing a Barrett, and he was coming off like 6 rounds at a second out of a frigging Barrett, firing 50 BMGs. That the man is not human. He's got to be a space alien.
Yeah, he's certainly a freak of nature. It's amazing what he can do with a firearm, and I don't know. and he just continues to amaze people. No matter how long he's been at it, no matter how old he's starting to get, he just keeps performing at levels that are beyond belief.
Yeah, absolutely. Next story I want to get to here. This one I got off of Bearing Arms. It's a John Petrolino story. This one kind of gave me a little bit of giggles. San Diego County gun owners acting on behalf of their members, and of course on behalf. Well, let me give some background here. Nathan Fletcher is the I want to say he's the county attorney for San Diego, and he's in a little bit of hot water legally. I got this again from John Petrolino's story. San Diego County gun owners acting on behalf of their members, and of course on behalf of Fletcher's ideology that he strongly holds on to, penned a scathing letter to new law enforcement officials of Fletcher's district asking the status of a gun violence restraining order be issued. The letter reads, law enforcement leaders, as you know, there are many current laws concerning firearms with which our organization disagrees, and we continue to work on getting them overturned. I believe we all agree, however, that special treatment of elected officials should never be tolerable. Last week, a lawsuit against Supervisor Nathan Fletcher was filed, which includes accusations of sexual assault and battery, sexual harassment, and other illegal behavior. It is not unusual for those accused of this level of illegal activity to have their concealed carry permit revoked and a gun violence restraining order filed to remove all access to their firearms. In addition to the lawsuit, Supervisor Fletcher released a statement stating he is too mentally unstable to continue with his campaign for state senate and that he is entering treatment for addiction. The purpose of this letter is to ask for an update on the progress to revoke Supervisor Fletcher's CCW and to file a GVRO against him. He has been very vocal about his support for GVROs and for heavily restricting CCW holders, especially when they are accused of violent crimes. I look forward to any progress update you can give me. Sincerely, Michael Schwartz, San Diego County Gun Owners PAC. I'm not going to read what this guy is accused of. It shocked me, and it takes a lot to shock me. But for this guy to do what he did and expect to be able to keep his concealed carry permit and his not to be able to keep his freedom, it just good on San Diego County gun owners. This is almost a gotcha for them. Now, speaking as Paul Lathrop, Deputy Director of New Media for the Second Amendment Foundation, everyone is innocent until proven guilty. I believe that he should have to put up with the laws he put forward. However, in the real world, I don't think anything should be done until he is found guilty. What do you think?
This is sort of, I don't know, good to see in terms of he's getting a taste of his own medicine, so to speak. Mm-hmm. But at the same time, I don't like these sorts of gun violence restraining orders. I don't like these extreme risk protections orders, or what's more commonly called red flag laws, because they turn due process on its head. They take away your rights and then give you process later. And that's fundamentally, I think, against the Constitution and the Bill of Rights. The Fifth Amendment says that you shouldn't be deprived of life, liberty, or property without due process of law. And here they're taking your liberty and your property by taking away your firearms before you're ever adjudicated to be dangerous to you or anyone. It can be based on mere allegations in a domestic violence situation, divorce situation, or just somebody who wants to make your life difficult. So I don't like these red flag laws. Indiana, unfortunately, Indiana's mostly good, but Indiana was the second state to adopt a red flag law. So Indiana gets a bad mark in that regard. But in Indiana, which is of the states, I think 19 states that have red flag laws, you get a hearing after 14 days. So you don't get process after your freedom is taken away until 14 days later. And only then do you have a chance to get your firearms back. But the problem is, like we've talked about on shows in the past, is that judges are reluctant to um, side with the individual over the government because if something does happen, they don't want to be seen as having blood on their hands. So judges are inclined to side on the government side in exercising these extreme risk protection orders or red flag laws. So um, if you're lucky, you'll have an attorney at that hearing, but you're not entitled to one. They're not typically appointed. So you'd have to come up with the money to get your rights back, essentially. So, like I said, it's got due process exactly flipped on its head. Nope, you're muted there, Paul.
The biggest problem I have with most states' red flag laws, and that there are many problems, starting with they don't do any good, but the biggest problem I have with most states' red flag laws is something there's a legal term in most of them called ex parte, meaning you aren't even notified before there's a hearing to take away your rights, let alone being allowed to participate and have an attorney present and all that good stuff. They meet, they decide, yep, we're pulling his gun rights, and nobody, you have nothing to say about it until after the fact.
Right. Fortunately, in Indiana, that's not the case. You are entitled to a hearing, but even in states where you are notified and you do get a hearing, even if it's 14 days later, like I said, you don't get an attorney. If you do find an attorney that will help you out, they likely won't be prepared for that hearing within 14 days. So you're talking about a pretty lengthy process. And then if the judge does determine that you are dangerous and that your firearms should be seized, you don't have an opportunity to get them back in Indiana for another 6 months. So it's a lengthy process to get your firearms back.
Well, and we're going to continue on talking about red flag because our next story is about red flag laws. This one off of Ammo Land. A New York court affirmed that due process rights must be taken into consideration when enforcing so-called red flag orders and vacated New York Governor's Kathy Hochul's executive order for enforcing extreme risk protection orders or red flag orders. That is consistent with what NSSF has said from the beginning about ERPOs. If an individual is going to be deprived of the fundamental constitutional rights, they must be afforded the opportunity to examine and challenge evidence brought against them. They must be afforded due process of law. In New York's case, the court requires that any red flag order must be accompanied by a determination from a physician or psychiatrist that's already part of New York's laws. The court noted that New York's mental hygiene law states, quote, a person's liberty rights cannot be curtailed unless a physician opines that a person is suffering from a condition likely to result in serious harm. Further, in order to extend any such curtailment of liberty beyond 48 hours, a second doctor's opinion must be obtained, and such an opinion must be consistent with the first doctor's opinion. Amanda and I talked about this story on Wednesday, and this is the New York Supreme Court speaking. Interestingly, the New York Supreme Court is the second highest state court in New York. The Court of Appeals can overturn the Supreme Court's decisions. That was fascinating to me. But the Supreme Court of New York has decided that, look, rule of law does stand in New York, which is good news, man.
Yeah, absolutely. And there's a link in the article to the NSSF website where they give some thoughts and insight about what they think red flag laws should provide in terms of due process. And I think this mechanism of having a medical opinion prior to the deprivation of your rights and the continued deprivation of your rights beyond 48 hours is certainly better than what most states with red flag laws have. But what's important is that most states do not have any sort of pre-deprivation hearing. So they take away your rights, they take away your firearms, and then they provide you a hearing later. And that's just fundamentally a problem with most states' red flag laws. So you have to basically prove that you're not dangerous. Of course, that's not the burden. That's not what the law says in most states. The law says in most states that the state has to show by clear and convincing evidence that you're dangerous. But in reality, the burden is on you as a practical matter.
Yeah. Let me get this one up from David. He says, jump through hoops to have your rights. That's in states with red flag laws, and especially the wider the net they have to the people that can report you and request an extreme risk protection order, the more people in there. That's exactly right. You essentially, Alex, you have to prove a negative, which is not possible. You have to prove you are not a danger, and that's awfully high burden.
Yeah. Yeah, and it treats, and this article from Ammo Land points this out, that it treats, or it discusses this issue, it treats the Second Amendment as a second-class right, which is clearly not what the Supreme Court said in Bruin. It said it should be treated like the First Amendment, it should be treated like the Fourth Amendment, it should not be treated as a second-class right, and you can't just take it away with no due process. There's only one command that's stated twice in the Constitution, and that's due process, in the Fifth Amendment and the Fourth Amendment. That tells you how important due process is and how fair procedure is a fundamental cornerstone of our justice system. And these red flag laws just do away with it.
All right, we're running out of time. I want to get to one comment from earlier, going back to talking about Jerry Mikulek. Charlie Cook said, Jerry did a video, Jerry versus M16, 10 rounds. The M16 was a fraction faster. Jerry was more accurate. So we could replace an entire platoon of the Army with Jerry. I mean, there you go. So
yeah, and of course that's what's so bad about bump stocks we were talking about earlier, right? Is that it's extremely difficult to shoot a firearm equipped with a bump stock accurately. But if you're Jerry Miculek behind the gun, you can shoot just as fast and a whole heck of a lot more accurately.
There you go. There you go. Let me get this one in from Robert. I was wrong. Let me get this one in here. In New York, the Supreme Court is the trial level, and it has an appellate division that is the next higher court. The Court of Appeals is the Court of Appeals is their highest court. You know, most states, you get to the Supreme Court, I think it's like 49 states, you get to the Supreme Court of Indiana, you get to the Supreme Court of South Dakota, Nebraska, wherever. That's it. Yeah, New York, they do it different.
Yeah, in most states we think of Supreme as the top, right? So I don't know what New York's thinking, but that seems odd.
All right, on the way out, man, if you would, please tell us about Forge of Freedom podcast and anything else you want to plug, man.
Yeah, so obviously I care a lot about the Second Amendment and our right to keep and bear arms, but that's not my only passion. I care more broadly about freedom, and I decided to start a podcast discussing issues related to freedom. It's Forge of Freedom. It's available on YouTube, Rumble, and most of your podcast streaming platforms. I release a weekly episode, and I talk about firearms, but I also talk about lots of other issues, jury nullification, civil asset forfeiture, qualified immunity. Talked about Stoic philosophy last week. So there's a broad range of topics, and like I said, it's available on YouTube, Rumble, and podcast streaming platforms. And I release it on Sunday afternoons. So if that's of interest to you, check it out.
Very cool. On my end, I would like to invite everybody to come next week, or not next week, tomorrow, and talk with us. We're going to be having Beth Alcazar, Dan Waz, and Rob Morse are going to be here for the weekend edition of the Bullet tomorrow, noon Central Time. Also, after tomorrow, the weekend edition of the Bullet is going to move to a 5 p.m. start time, just to make things a little bit more even throughout the broadcast week. So that's going to do it for me today. Come join me tomorrow, noon Central Time. Until then, everybody, thank you podcast listeners for listening. Thank you everybody who's commented for commenting, and we'll see you next time.